I'm Jeff Rosen. I'm a law professor at George Washington University and a co-editor with Benjamin Wittes of Constitution 3.0, Freedom and Technological Change. Yes, Oren Kerr has a very helpful and illuminating suggestion when he emphasizes use restrictions. His basic point is that the collection of data is very hard to regulate. The cat is out of the bag. We're already leaving so much data trails everywhere already that an attempt to prohibit it being from collected and even integrated may be foolish. But he emphasizes use restrictions can make a big difference. There's a model here, the Germans, who have an obvious and daunting history of totalitarianism, allow their intelligence services to have broad access to data without a warrant. But they can only pass that data on to law enforcement if they find evidence of terrorism or other serious crimes. If the intelligence services were to find evidence of low-level wrongdoing, like adultery, for example, they would not be able to share that information with law enforcement. That's a quintessential example of a use restriction. You can share the information when it relates to a serious crime, but not when it relates to a low-level crime. And Professor Kerr argues, and I agree with him, that similar use restrictions in the US would go a long way toward alleviating a lot of the concerns about unlimited government access to data. We'd be less concerned about surveillance on an open planet-like system if the police were only allowed to use the information they learned to prevent murder and terrorism and not to go after people for lying on their tax returns. Unfortunately, and Professor Kerr doesn't examine the practical likelihood of this, but I think he would argue, and I'd agree, that it's not likely to pass in practice. It's hard to stand up in Congress and say, we have to allow the police to go after the murderers, but not the adulterers. Imagine standing up and saying that. Or as I found when I interviewed Larry Ellison of Oracle years ago, who runs the largest database company in the world. And he had just proposed, it was right after 9/11, to offer the US government free software for databases. Coincidentally, they were going to be Oracle databases. And also coincidentally, the maintenance and upgrades weren't going to be free. But he wanted to centralize all the data the government holds in an Oracle database and check people before they go on airplanes to see whether they had anything bad in their past. And I objected, but wouldn't this mean that if you were late on your child support payments, then you could never board a plane or get into a government building? It's one thing to keep a terrorist off, but another thing to keep off an adulterer. And he got very indignant and said, well, what's so great about protecting people who are late on their child support payments? You know, if you do something wrong, you've got to take the consequences. Nothing to hide, nothing to fear. And that's a very popular position in the country as a whole. John Ashcroft, the Attorney General, said a similar thing when I suggested use restrictions in an interview with him. So in a democracy, it's tough to argue for use restrictions. That's why I think that the Europeans are more likely to impose these use restrictions through non-democratic, or rather non-plebiscitary bodies, not through their legislatures, but administrative bodies. They put more faith in the power of experts to restrict information. Their data privacy commissioners have more power, so you almost need an administrative regulation to implement use restrictions. We can't rely on politicians to do it. Jack Goldsmith does have a wonderful essay about how much more of this surveillance is already going on than we imagine. And he talks about the Einstein III program, which the government has acknowledged in the vaguest and most general terms. And under Einstein III, in an effort to avert cyber attacks, the government is asserting the power to scan all internet traffic coming from abroad, and when it detects any suspicious patterns, to intervene in real time to destroy the information. This is a version of the warrantless wiretapping that the Foreign Intelligence Surveillance Act and other laws seem to forbid. But, says Goldsmith, could it be justified in the name of exigency? He thinks that you'd need a legislative fix. Congress would have to pass a law explicitly authorizing Einstein III to put it on really solid legal footing. But he also notes that in order to be consistent with Fourth Amendment values, although not necessarily with the Fourth Amendment itself, you would need a series of use restriction-like devices. He talks about minimization requirements that would require the data to be destroyed after a particular period of time if it didn't contain anything suspicious, independent oversight by judges, and sunset provisions that would ensure that the authority would expire after a certain period of time unless Congress wanted to renew it. So for him, I think he imagines that these restrictions should be embraced by Congress, although he's not all that optimistic that they will be. He notes that similar restrictions were recommended by things like the Berger decision, the Supreme Court's decision regulating wiretapping. There, Congress did respond by passing the kind of restrictions that the court recommended. I think we'll see whether the Congress responds to the Jones decision by accepting Justice Alito's suggestion that we need a global positioning system legislation, and that it's not up to courts alone, but that some sort of legislative regulation of access to geolocational data is necessary. But this is such an important problem because it's a solution without a natural constituency, and it's just not obvious, I think, to any of our authors exactly whether the good results that they suggest will in practice be adopted. Yes, the Jones case is interesting and encouraging on a lot of levels. It's interesting and encouraging that all of the justices, liberal and conservative, rejected the position that there's no privacy in public. It's encouraging that each of them contributed something promising for the future. So it's a good thing that Justice Scalia and his colleagues said that trespass law may not be the ceiling for Fourth Amendment protections, but it's at least a floor. It's a good thing that Alito was so willing, in a very creative way, to entertain and recognize the difference between short and long-term surveillance. And it's great that Justice Sotomayor called for re-examining the third-party doctrine, which says that data that I share with a third party like Google is data in which I abandon expectation of privacy and which Google can then share without limitations with the government. It's also encouraging that the justices seem to be as tech savvy as any normal citizen in this world. You know, there was a lot of ridiculing of them on the blogs for their supposed tech Ludditism in the oral argument about the privacy of a beeper, the Kwan case. Justice Roberts was criticized for asking a question that seemed not to understand what text messaging technology was, and others noted that Justice Kagan, the youngest justice, grew up with a video game technology that went no further than Pong. And then, of course, in the Communications Decency Act case back in the 90s, there were apparently, according to press reports, porn tutorials in the Supreme Court library where Larry Lessig, who was then a clerk for Justice Scalia and is also an internet guru, had to set up computers and show the justices how to sign on and access internet pornography, no doubt sternly cautioning them not to engage in this hideous vice in their spare time. But in this case, we learn that the justices are citizens of the new digital highway along with the rest of us. They get Easy Pass, they use Kindles, they use email, they have smartphones, and therefore they are not going to allow the fact that they are old and in that sense less tech savvy than younger people. They won't allow that to prevent them from engaging this crucial question of how to translate the Constitution in light of new technologies.